Um, Good morning. It's 11 o'clock, so I'm going to start the webinar. I hope that you can see and hear me okay. I have to take that on trust. I'm Stephen Tromans, KC. I'm chairing this webinar on the important and the difficult topic of Scope 3 emissions. I'm sure that the fact that you have signed up for this event means you're already well familiar with what Scope 3 emissions are, and that in Finch, the Supreme Court found 3-2 in June of last year that Scope 3 emissions were indirect effects of hydrocarbon extraction requiring assessment. So we're trying to take that on a step, really, in this short webinar this morning. The decision, as you probably know, had immediate implications for projects including North Sea oil and gas and the proposed new coal mine at Whitehaven. A lot of people asked at the time of Finch what the practical implications would be in how this information, which now had to be provided on the assessed effects, would be presented and would be used. And those questions aren't unique to Scope 3. They could equally well apply to Scope 1 or Scope 2 emissions, as we'll see from some of the cases we're going to discuss this morning. So answers are slowly starting to emerge, I think, with new guidance, which Ruth is going to talk about, and new case law, which Steph is going to address. So to help us understand these issues, I've got with me two highly qualified colleagues. Ruth Keating acted with me in representing the OEP in Finch. Steph David has been involved in many climate change cases and is one of the principal authors of the groundbreaking book, The Law of Net Zero and Nature Positive. She's holding that up, published earlier this year, and which has, pleased to say, attracted some very favourable reviews. I won't say any more about either of them because you can look at their detailed CVs online if you wish. So how this is going to work is that Ruth and Steph will present in turn for about 15 minutes each using PowerPoint slides. You'll get materials after the webinar, which will include the PowerPoint slides. I'll mention that when we conclude at the end of this morning. Please feel free as we go through to use the Q&A function, which I hope you have on your device or computer, to pose questions, which we will look at and try and deal with at the end, or indeed online as we go through if we can. Finally, just before I hand over to Ruth, I'd like to mention one upcoming event. The Climate Change Group within 39 Essex will be presenting a half-day live seminar in Chambers on the morning of Thursday, the 13th of November. It's Thursday, the 13th of November, which will include discussion on a wide range of subjects around the general topic of climate change, which will include international law, investor protection, and criminal law. So some quite interesting peripheral, or maybe not so peripheral, issues. More details on that will appear on our website in due course within a few days, but do please save the date and join us if you can. So I'm now going to hand over to Ruth Keating, with our first presentation. Thanks very much.
That's brilliant. Thanks, Stephen. So I'm conscious that given the nature of who's signed up for this webinar, you'll all be very familiar with the Supreme Court decision in Finch. Of course, in that case, it was concerned with retaining and expanding an existing onshore oil well site. And so, as Stephen has said, that has led to lots of other questions about how do the principles in Finch apply more widely, and I'll be focusing on offshore oil and gas projects. So in terms of the next slide there, what we see is an update on where we are with the most recent government guidance. So offshore oil and gas projects are subject to a different regime, the Offshore EIA Regulations 2020, which are different to the EIA Regulations 2017, which were at the heart of the Finch judgment. But the interesting point behind the new government guidance is very soon after Finch, the government acknowledged that given the offshore EIA regulations similarly transpose the EIA directive, that guidance would need to be updated in light of Finch. And so there was a pause of considering offshore oil and gas projects from the 29th of August 2024, pending the publication of this new guidance, which we now have. So the first point, or the first stage, was that the government consulted on this new guidance between October 2024 and January 2025. And then during the summer, on the 19th of June 2025, they then published their supplementary guidance. And the next important step, of course, is that in light of that new guidance, oil and gas production projects have now been restored following that pause, and they can be considered through the EIA process. So looking at the next point there, the next slide, what was the influence of Finch in terms of this guidance? And I think it's fair to say, reading the points that are in the guidance, but also what's said at the outset of the guidance, Finch was very clearly front and centre. And 3 specific passages from the judgment were highlighted to the reader of that guidance on page 4. So the first is paragraph 3 of the judgment, where Lord Leggett said that the object of an EIA is to ensure that the environmental impacts of a project is exposed to public debate. That was a very important part of the Finch judgment. And that if such consent is given, it is given with the full knowledge of environmental costs. So I'm sure that's something we'll discuss later in the Q&A section, but that is very much front and centre. The idea that certain projects may even be consented to, even if the scope 3 emissions are high, but they must be consented to in the full knowledge of what that environmental and climate impact is. The second point there that the guidance highlights is paragraph 97 of the Finch judgment. And that is where Lord Leggett said, wherever greenhouse gas emissions occur, they contribute to global warming. And that is why the relevance of greenhouse gas emissions caused by a project does not depend on where the combustion takes place. So again, that is a kind of guiding principle behind this new guidance. And finally, paragraph 7 of the judgment is highlighted, and it is not disputed that these emissions, which can be easily quantified, will have a significant impact on the environment. So I'll come back to these as I describe the new guidance, but I think it's important to remember these 3 passages as somewhat of the kind of guiding principles behind this new supplementary guidance. And I think they have very much informed the policy outcomes and decisions that we see in terms of how considering an EIA will take place. So on the next slide, we have an overview of the guidance itself. Now, I think the industry was waiting a lot of time for this guidance, and there was an extensive consultation process. The guidance itself is not a considerable document in terms of length. It runs to just 18 pages. So it very much is a document that is worth poring over and considering what it means in practice. It addresses some of the key concerns which have been raised about offshore oil and gas. So market substitution arguments, the drop in the ocean arguments, as they're called, and finally, how carbon offsets and removals should be treated in the context of oil and gas projects. The guidance itself applies to 3 scenarios. So the first scenario is the one we'll all be very familiar with. It's primarily focused on projects falling under Schedule 1 of the offshore EIA regulations. So they require a mandatory environmental statement, and they require development and project and production consent from the North Sea Transition Authority, or the NSTA. The second scenario where this guidance is going to apply are projects which require a screening decision to determine whether an environmental statement is required. So Schedule 2 type projects. And the guidance says it should be considered when providing information on Scope 3 emissions in that screening application, and subsequently applied if an environmental statement is required. And the final scenario where developers are going to have to look at this guidance is where a consented project seeks to amend its daily production rate, and there's therefore going to be a change in the total amount of hydrocarbons produced over the project's lifetime. So again, very sensible that the guidance would apply in those types of circumstances. And all of those points leads us to the next point, which is how is this going to work in practice? I think that's the really burning question that this guidance poses. So the headline point is that developers must assess the impact of Scope 3 emissions from downstream combustion. That is the fundamental underlying principle in the guidance, and that is where I think we see those 3 paragraphs from Finch really being carried through into the fundamental point which this guidance is seeking to address. And that applies even if the developer argues that hydrocarbons will substitute other sources, or indeed that the hydrocarbons won't be fully combusted. In terms of practical steps, it's highlighted on your slide there. On page 7 of the supplementary guidance, the IMEA's 2022 guide to assessing greenhouse gas emissions and evaluating their significance is provided as a kind of 6-step approach that a developer might wish to follow in assessing greenhouse gas emissions. So first, they'll have to set the scope and extent of the assessment. Second, they'll have to determine the baseline. Third, they'll have to decide on the emissions calculation methodologies. Fourth is going to come that data collection phase. Fifth, they're going to have to then calculate and determine the greenhouse gas emissions inventory. And finally, you consider mitigation opportunities and repeat those steps 4 and 5. So they're the very practical points. I mean, I think it would be fair to say, looking at those, that one would have to add a lot of meat on the bones to really putting forward an ES. But that is what the guidance then does. So I'm going to focus on 6 of the elements that I think are really important in the guidance to address that 6-stage test. So the substitution arguments, the approach that should be taken to global emissions, the methodology, estimating emissions, assessing significance, and finally mitigation measures. So looking at the next point there that you have on your screens, that's the substitution argument. So those listening will be very familiar with this type of argument. It essentially goes that the market substitution is the idea that there won't be an aggregate increase in greenhouse gas emissions, since the production to meet market demand for oil and gas would come from another project elsewhere if the relevant field isn't opened. So in other words, it's the idea that the proposed production would replace rather than supplement production elsewhere. Now, I'm sure some of those who've joined us today that will immediately draw to mind the Whitehaven coal mine example, where this argument was used. And I think in the context of that case, and more generally, the criticism that has been made of substitution arguments is that they can often lack a supporting evidence base, which makes good that substitution argument. Now, in the new supplementary guidance, substitution arguments are directly addressed, and OPRED say that substitution does not affect whether Scope 3 emissions need to be assessed in the first place. And that's a really important aspect of the guidance. So if a developer does want to put forward substitution arguments, it doesn't make a difference as to whether Scope 3 needs to be assessed. It does. But what it could make a difference to is contextualizing the emissions. But even then, that needs to be supported by credible evidence, and OPRED is clear on that in the guidance. The next point that the guidance very clearly addresses is how you deal with the impact of global emissions. So if we go on to the next slide, we'll see how that is dealt with. So unsurprisingly, the guidance says that the assessment needs to include the likely significant effects of a project, and that needs to take into account global greenhouse gas emissions. Page 8 of the guidance expressly says that OPRED would expect that these considerations will feature in any assessment of greenhouse gas emissions. So that is a very substantial point that's now included in the guidance. And I think what that really does is it addresses 2 principal points that emerge as themes when one reads the whole guidance, which is first, that the decision maker needs to be able to assess all the relevant information, and global emissions are very much an important part of that. And the second point, and I'll return to this, is that numbers need to be contextualized and explained. So it isn't enough to just provide raw data to the decision maker. That data needs to be put in context. And one important way of doing that is by explaining it by reference to global greenhouse gas emission numbers. And the final point to note on this, and it's on the slide there, is that I think this is a point where, even though the guidance doesn't refer to Finch, it very much has the guiding principles from the case in mind, and drawing everyone's attention to paragraph 97 of Finch, where Lord Leggett said, if an activity is carried out which will inevitably result in significant greenhouse gas emissions, people who carry on the activity cannot be heard to say those emissions are not effects of our activity because they are occurring far away among people of whom we know nothing. So again, I think that's a really important guiding principle here, that the global impacts of these types of projects go part and parcel with hydrocarbons, and they need to be considered, and they need to be at the forefront of the decision maker's mind. The next slide goes to one of the really burning questions behind this guidance. So this is methodology. And this is a topic where developers have been asking for clear guidance in terms of the types of methodologies they should be applying. Now, here the emphasis on the supplementary guidance is on conducting the assessment in accordance with, and these are the words used, current, credible, and widely accepted principles. But what the guidance doesn't do, it doesn't give any specific methodology that needs to be used by a developer. I think that's unsurprising, given part of the emphasis on the guidance is using the most up-to-date methodologies, and that might not necessarily be something that is static over time. And the second point is that I think the government's consultation response was interesting on this. So at the same time as publishing the guidance, the government also published a consultation response, and they said it's for developers and their competent experts to assess the effects of a project on the environment. And while the guidance sets out a number of expectations as to how that assessment could or should be done, Opred accepts that alternative approaches may be possible or even preferable. Now, on page 10 of the guidance, certain methodologies are referred to. So the guidance is trying to be helpful in that respect. So the IPIECA's or the Global Oil and Gas Association's 2016 guidance is referred to. The GHG Protocol 2013 is also referred to. So there are publicly accepted tools that are referenced in the guidance, but no specific methodology is prescribed by Opred. And I think bringing all of those points together is the big question of what baseline is to be used. So the supplementary guidance reflects the consultation responses, which was one of the key messages that came back from those who responded to the consultation, was that the baseline scenario should be 0. So the scope 3 emissions would not occur if the project doesn't happen in the first place. And so that had to be the baseline that's put forward to the decision maker. But when determining that baseline, one had to look at, the global baseline and also the national baseline again, and also look at the lifetime of the project. So the methodology, I think, is one of those points where people wondered, would Opred be more specific in terms of the methodology they prescribe? They haven't, but I think what that does do is put an onus on the developer as a kind of evolving obligation to stay up to date. And so it can't necessarily be assumed that the methodology that's used in 2025 will be the same methodology that should be used in 2027. That is something that a developer will have to take account of. On the next slide, we see another one of the core aspects of the guidance, which is estimating emissions, and it's a rebuttable presumption of full combustion. So in Finch, all the parties agreed that it was inevitable that the oil extracted would be sent to refineries and that refined oil would eventually be combusted. The difficulty, of course, in terms of its wider application is that won't always be the situation. And so oil and gas companies might argue that some of the extracted oil could be used to produce plastics or petrochemicals, for example, and therefore it won't be combusted. And so the Opred guidance directly addresses that situation. It says that the starting point for these environmental statements is a rebuttable presumption that all produced oil and gas over the lifetime of a project will eventually be combusted. So that is very much the starting point. And Opred says that for transparency and comparability, that scenario needs to be presented even if the developer provides sufficient evidence to rebut that presumption of full combustion. And so that is where you see on the slide there the reference to P10 data, that you have to provide the highest anticipated hydrocarbon production as part of your environmental statement. So very much a risk-averse and cautious approach that Opred is taking. We then move to the next slide, and I think this is, for me, the most interesting aspect of the guidance. It's assessing the significance. And I think, Steph, it's something that you might pick up later as well in your discussion. In the context of hydrocarbon extraction projects, applicants, we'll all be aware, often raise the argument of a kind of drop in the ocean argument. So essentially, that given that projects' emissions are so small compared with the total global emissions, it will be a drop in the ocean, and so consent should be granted. Now, this is where Opred, I think, really changes the mood music in terms of what is required on a developer. So the supplementary guidance emphasises that the environmental statement must use a matrix to assess the magnitude and the significance of the scope 3 emissions, and that includes cumulative effects. And Opred expressly uses the word to contextualise the emissions. And that's where we see on page 12 a really important point where Opred says, Opred therefore expects that environmental statements will both include a clear assessment of the magnitude of scope 3 emissions and provide appropriate context to support a determination of significance. And the reason why I think this point is really interesting is because this is a challenge really at the heart of the EIA process, which is one could cynically think that a developer might not have an interest in, for instance, contextualizing the figures in a way that sounds significant. And, I think an interesting example of that is in the Rosebank decision, which will obviously be made in the near future. But so on the 30th of January 2025, Uplift estimated that the emissions from Rosebank would amount to more than 200 million tonnes of CO2. So what does that tonnage look like? Well, Uplift put that in context by saying that would be the same combined annual emissions of 700 million people living in all 28 low-income countries in the world. Now, those are the kind of contextual perspectives that I wouldn't imagine a developer would use in their application. But I think what that tension really shows is the kind of driving force behind a decision like Finch and the driving principle behind guidance like what OPRED has provided, which is that it is for the developer to provide accurate information and to put context on it. But the important next step that takes place is that the public and the decision maker interrogate that kind of information. And given Uplift was able to put that kind of analysis on the numbers, I think that shows the power of having this type of information available in an environmental statement. The final point in this is on page 12 of the guidance. So really importantly, what OPRED says is that its current view is that characterising Scope 3 emissions from a project solely in numeric terms against global greenhouse gas emissions would not on its own provide a meaningful expression of global effective Scope 3 emissions. So that for me is really the high point of the guidance, is to say one has to put context on the figures, and the person who should do that in the first instance is the developer who understands that context. The final point to address on this is mitigation measures. So that's on the next slide. So this is a question that people have been asking, practically speaking, is for Scope 3 emissions where they can be very high, particularly in the context of oil and gas, can there be mitigation measures? So the headline point on this is page 13 of the guidance. And there's some interesting analysis from OPRED there. So OPRED has said, a developer may not have direct control of mitigation measures for avoiding, preventing, or reducing Scope 3 emissions, unlike the situation for Scope 1 and 2 emissions. And they continue that OPRED is not recommending or discounting any specific mitigation measures, but any such proposals must not be speculative. So there's a couple of interesting points that come from that. As Stephen said at the outset, this webinar is very much about Scope 3 emissions, but Scope 1 and 2 can often be assessed through a similar lens. And I think there's some interesting guidance there on Scope 1 and 2 emissions, even if it's not the focus of what OPRED were advising on. But the second really interesting point is that OPRED currently isn't considering any of those kind of mitigation measures or recommending them. And I think that does leave the developer in a situation where I would imagine in the months and years to come, that is a point where we'll see development, where developers might propose a mitigation measure. But of course, given OPRED hasn't given a list of what they consider to be an adequate mitigation measure, that would have to be considered on a case-by-case basis. And I think the second point that's really interesting is that they said those measures need to be transparent and easily verifiable. Now, what's not clear looking at that is that OPRED have said they would consider emission removal measures to be the best way of having a mitigating measure. Now, the difficulty in the context of Scope 3 is when one usually thinks about emissions removal measures, one thinks of things like a strategy of implementing low greenhouse gas procurement policies or encouraging supplier decarbonation or developing zero-emitting products. But of course, that is in some ways antithetical to hydrocarbons as they operate in terms of a Scope 3 number. So I think that's something very much to watch. And the final point on that point of mitigation is many people have wondered, well, how will OPRED deal with carbon offsetting? And what OPRED have said in this guidance is they said they are not considering carbon offsetting to be a sufficient mitigation method pending the outcome of the government consultation on the implementation of the principles for high integrity voluntary carbon and nature markets. So again, that's an area for future development once we have that outcome from the government. And this comes to my final slide before I pass over to Steph. And this is what is this all going to mean in practice? So all of us following this area will be very familiar with the Court of Session's decision in February 2025, where Jackdaw and Rosebank were declared unlawful in light of the Finch decision. So they've had to go back to the drawing board. Now, in September of this year, Shell submitted a fresh environmental impact assessment for Jackdaw, and Equinor submitted one for Rosebank. So I think they are going to be the first projects where we really see this guidance put to the test, and we see how OPRED interrogates these types of projects and the kind of information it requires from developers. And the final word of caution on all this, and I think it's an interesting case, is on the 8th of August 2025, the UK received its first International Centre for Settlement of Investment Disputes arbitration. Now, the interesting point there is that the driving force behind this case is the developer for West Cumbria Mining, of course, the Whitehaven project. It's the first time the government has been challenged in this type of arbitration for its actions around climate, but I think it certainly demonstrates the sensitivities around these types of policies, and that a difficult line sometimes has to be drawn in the context of these types of decisions. So over to you, Steph, to give us a bit of a forward-looking view on the case law.
Thanks so much for that, Ruth. Just to pick up on one point which I seek to draw out in my talk is in relation to the question about how do you assess the sufficiency of the environmental information gathered as part of the EIA process. It obviously is an important question, and I'll go to how developers approach their environmental statements and also how decision makers assess that information. In terms of the point Ruth just made regarding the supplementary guidance being tested in the context of the Jackdaw project, I think it's worth noting that OPRED actually sent a notice only sort of 10 days ago, 22nd of September, under the relevant regulations requesting further information from the developer. That information involves essentially evaluating the context of a global baseline scenario of greenhouse gases and the current state of the climate, and also required them to provide an assessment of cumulative effects. They went on to say that the developer needs to provide further information regarding the appropriate conversion factors and clarification as to how those conversion factors have been selected. On the issue of substitution, again, OPRED have reiterated the point made in the Whitehaven case in respect of it being a sufficient evidential base for that argument and have required further information on that point. Finally, not so much in the environmental context, but thinking about the economic benefits of the development, OPRED have also asked for further information regarding the breakdown of direct, indirect and induced jobs as a result of the project. So the response is due tomorrow, as I understand it, and very much goes to the point as to the extent to which the decision maker will interrogate the information provided by the developer in order to discharge their obligations under the EIA regime. So in terms of then my talk, so I'm going to think about how the principles in Finch have been applied in the energy context and in relation to other infrastructure projects. Whilst we touched upon definitions at the start, I think the headline point to remember, of course, is that scope 1, 2 and 3 emissions aren't defined in either the EIA directive or the EIA regulations. And therefore, although there has been a focus on scope 3, given the very nature of the facts in the Finch case, the principles that Lord Leggett laid down do have application in respect of scope 1 and scope 2 emissions. And that's obviously important to bear in mind in the context of how these principles are applied in other sectors. So the main case I want to focus on is the Court of Appeal decision in the Boswell case. So as many listeners may be aware, Dr. Boswell is very interested in this question of how you assess the significance of environmental effects. He has been involved in previous cases in respect of the assessment of those effects in the road context. This particular decision concerned another infrastructure project. So it was essentially a new gas-fired electricity generating station at Teesside with carbon capture, utilisation and storage. The decision was taken as an application for a development consent order under the Planning Act regime. And therefore, in my view, it provides an interesting indication as to how the intersection might play out as between the Planning Act regime, in particular policy set out in the National Policy Statement, and the obligations in an EIA. It also considers the scope of the ratio in Finch, before considering, again, this issue of significance of greenhouse gas emissions, whether policies can set thresholds, and whether it actually is a legal obligation to contextualise, notwithstanding what the OPRED supplementary guidance says. And again, coming back to the point that I made before in respect of how you go about assessing the sufficiency of environmental information. So in terms of then the legal framework for determining these kinds of applications, it is set out in detail in the book. We have a chapter on the Planning Act regime and nationally significant infrastructure projects. But in short, for those who aren't familiar with the regime, essentially where there is a relevant national policy statement, there is a requirement in section 104 to the effect that the decision maker, namely the Secretary of State will decide an application on development consent order in accordance with that national policy statement, unless one of the exceptions apply. A national policy statement can specifically prescribe the relative weight to be given to specified criteria, which is a really important point, and that we'll come back to in the course of discussing this case. The other point to flag is the relevant EI regulations here are the infrastructure regulations that set out in that second bullet point. And the appellant relied in particular on regulation 21, which again comes back to the point that whilst the burden in terms of providing the information falls on the developer, as Mr. Holgate, as he then was made clear in the Whitehaven case, the decision maker still retains the obligation to examine the information and reach a reasoned conclusion on significant effects. And again, this case is concerned with what a reasoned conclusion means. In terms of the policy context of this decision, so the relevant national policy statements were those from 2011. They have since been reviewed in light of the Paris Agreement and the Net Zero Obligation and the Climate Change Act. But in material part, they haven't changed, and therefore what was said in respect of the 2011 versions of the national policy statements applies with similar force to the 2024 designated versions, which are currently in place and will apply to forthcoming applications for development consent order. The critical paragraph is the one set out there, which is paragraph 5.2.2, which is essentially that the policy statement recognises that the carbon dioxide emissions are a significant adverse impact from some types of energy infrastructure, which cannot be totally avoided. So it doesn't just say they're an adverse impact, but recognises they will be a significant adverse impact. And then you look down the paragraph to sort of halfway through, the government has determined that carbon dioxide emissions are not reasons to prohibit the consenting of projects which use these technologies, being the carbon capture storage technology, or to impose more restrictions on them in the planning policy framework that's set out in the national energy policy statements. Importantly, that last sentence says that the decision maker, at that point in time it was the Infrastructure Planning Commission, does not need to assess individual applications in terms of carbon emissions against carbon budgets, and does not address the carbon dioxide emissions or performance standards that may apply. The reason being is that the policy decision that was taken was that it's sufficient to rely on non-planning policies in respect of the transition to net zero. So in terms of then the decision in this case, the Secretary of State determined that there was a relevant national policy statement, and therefore the application for a DCO had to be decided in accordance with it. There were no reasons to disapply that because none of the relevant exceptions in section 104 applied. The Secretary of State accepted the estimate set out there in respect of over 20 million tonnes of carbon dioxide equivalent for the development and the offshore elements of the development. They accepted the fact that cumulative whole life greenhouse gas emission would be a significant adverse effect, and that the effect carries significant negative weight in the planning balance. So the two principal issues on appeal. The first one was in relation to how the assessment of significance of the greenhouse gas emissions was undertaken. Essentially, what Dr. Boswell was saying was that reading the decision letter as a whole, it was apparent that the Secretary of State was applying the EMA guidance. The EMA guidance is guidance that Ruth referred to earlier, and it's the reference to the supplementary guidance in respect of offshore oil and gas projects. But what Dr. Boswell contended is that in taking this decision, the Secretary of State relied upon that guidance, but failed properly to apply it. The reason being is the EMA guidance is clear that when you're thinking about significance, the question is whether or not the project will contribute to the net zero trajectory. If you look at that third bullet point down, it's a significant adverse effect when it's not compatible with the net zero trajectory. And what the Secretary of State had found in this particular case was there was a significant adverse effect, but it was also compatible with the net zero trajectory, which, if they were applying the EMA guidance, would be a misapplication of that definition. The other point that the Dr. Boswell ran is in relation to Regulation 21, which I referred to earlier, and the need for that reasoned conclusion. The argument that was made was it wasn't sufficient for the decision makers simply to say that the emissions constitute a significant adverse effect. They had to go further than that and assess significance against some kind of benchmarking or contextualization. The second point to draw out is in respect of the actual decision-making process and how the EIA fits alongside the broader decision taken by the decision maker. Essentially, what Dr. Boswell contended was the judge at first instance, Mrs. Justice Levin, had erred in deciding that the paragraph I referred you to earlier, 5.2.2, essentially does two jobs. The first one is assessing the significance for the purpose of the EIA regulations, and the second is the weight to be treated that significance as part of the planning balance. So the court didn't accept Dr. Boswell's argument that the EMA guidance had been relied upon by the Secretary of State, whilst there had been earlier references to the EMA guidance in the context of more generally assessing the greenhouse gas emissions. It wasn't referred to in the specific context of reaching the decision that there was a significant adverse effect. The court determined the Secretary of State had evaluated the significance of the greenhouse gas emissions in absolute terms by contextualizations and by reference to the EN1 policies. So in terms of the related argument as to whether or not Regulation 21 required some sort of benchmarking or contextualization, the Court of Appeal also dismissed that argument and said that essentially the question of significance set out in the last bullet point is a matter for the individual decision maker. It's a matter of fact and judgment. Whether or not the decision maker chooses to benchmark is a matter for them, and there's no legal requirement to benchmark or contextualize, which again is a point obviously we'll need to return to when thinking about how this case sits alongside OPRED supplementary guidance. In terms of then the second argument, which is in respect of essentially paragraph 5.2.2, conflating different parts of the decision-making process, so the EIA part and then the broader kind of planning balance assessment. That was given very much short shrift, even though Dr. Boswell framed it as essentially the policy document deeming or prescribing the level of significance in respect of an effect on the environment, which is an interesting argument because clearly, that would seem to predetermine the outcome. If even before you've assessed the emissions, there is essentially an assumption written out in policy to the effect that there will be a significant adverse effect. But in any event, that was dismissed by the Court of Appeal, who said that we think it's entirely legitimate in principle and in the circumstances of the case to draw upon the national planning policy in the national policy statement, informing her conclusions on the significance of the greenhouse gas emissions, both for the purpose of the EIA and for the purpose of judging the ultimate planning balance. But it is worth also bearing in mind the observation of paragraph 90 of the Court of Appeal's judgment, which was essentially that there's no legal or practical reason why national planning policy should not provide guidance on the question of the significance of environmental effects of one kind or another. In terms of then Dr. Boswell's reliance on Finch, essentially the point that was made on his behalf was that national policy should not in any way circumscribe the scope of an EIA, because that's a separate matter of law in accordance with the EIA directive and the regulations made thereunder. That point again was given very short shrift on the basis that essentially Finch is analytically quite different from the facts of this case. This is not a case going to the scope of an EIA, but rather how the significance of the greenhouse gas emissions were assessed. And so the court determined there was no issue with the Secretary of State having conflated the impact of the emissions with the weight to be attributed to them. And Finch did not help Dr. Boswell in this case. The final point I really wish to make on this is in respect of essentially the environmental information point. What the court said at paragraph 90 is the adequacy of environmental information to meet the requirements of the legislation is ultimately a matter for the authority to decide, subject to rationality grounds. So in my view, the key word there really is, or key wording there really is, to meet the requirements of the legislation, which ties back to the point that Ruth made earlier in respect of the overall objective of the EIA regime being that a decision maker confronts the full environmental cost of the decision before making it. And that necessarily requires full environmental information, a comprehensive analysis of the environmental effects, and transparency so that the public can participate as part of a lawful EIA process. It is an important one because ultimately there is sometimes an incentive to provide less than full information when putting in environmental statements. And I would suggest that actually the benefits when developers are undertaking this work to be as clear as possible in respect of the information they rely upon, to provide the full carbon footprint assessment, provide the details in respect of how the conversion factor has been calculated and what inputs have been factored into it. Because that will, in my view, actually speed up the process rather than having multiple rounds of requested further information and possibly further rounds of consultation. The other point to flag is in relation to the case in Northern Ireland. I don't have a slide on, but essentially that's the A5 dual carriageway case. And the reason I flagged that case is one of the issues in that case was in relation to whether or not a further exercise undertaken by the Department for Infrastructure, which essentially was concerned with assessing the greenhouse gas emissions from induced trips originating from or terminating in the Republic of Ireland, whether that environmental information should have been put forward as part of a further consultation so that the public could properly participate in the process. And the court concluded in that case on that particular issue that the information was new and it was significant and therefore there should have been a further consultation on it. So indeed it ties back to the broader point I made in respect of transparency from the start in terms of how you calculate your greenhouse gas emissions and what factors are taken into account. Thinking then about how Finch has been applied in other contexts, it's not surprising that it has been applied in the agricultural context, obviously given the significant contribution agriculture makes not only to greenhouse gas emissions, but also to the environment more generally, as is recognised in the Squire case, referred to by Lord Legate in his judgment. So the first example I'd touch on briefly is the Caffin case, that's Dr. Caffin in Shropshire. The reason I touch upon it briefly is that it's not directly concerned with greenhouse gas emissions, but it is interesting to see how Mr. Fordham approached applying the principles from Finch to that case. So that development concerned 4 poultry units, and there were capacity of 200,000 chickens on site. The figure of 20 million was the figure given by the claimant in respect of overall chickens in Shropshire, which was recorded at the start of his judgment. But in terms of then the actual Finch case, the kind of 2 key criteria that Mr. Fordham identified was essentially an effect as a question of causation. You all are aware of that. There's a question of capability of meaningful assessment. And there's a third point in respect of matters of value to judgment. And in my view, this is potentially where there's a need to think about the Finch reasoning in greater detail, because essentially, whilst at paragraph 20 of his judgment, Mr. Justice Fordham points to a value to judgment being relevant to the question of whether an effect is likely, rather than the question of causation, which is a question of fact and law. When he actually then applies those principles in the context of thinking about digestate, there appears to be a conflation as between evaluative judgment going to whether an impact is an effect at all, which, as I say, is a question of fact and law. It isn't a question of evaluative judgment. So in that case, it's actually quite a short point, really. Essentially, he found that the local planning authority had not considered digestate at all, digestate being the product following it being put through anaerobic digestion. Essentially, there was a condition on the Planning Commission to the effect that the raw manure would be sent to an anaerobic digester or some similar waste facility. The argument was run on the causation point was that anaerobic digestion was some form of mitigation, and they sought to distinguish anaerobic digestion from oil refinery on that basis, which Mr. Fulham gave that argument short shrift and said anaerobic digestion is very much like the processing in an oil refinery, and therefore it was in effect for the purpose of the EIA regime. On the question of meaningful assessment, he also accepted that whilst in Finch it was obvious it could be assessed, there was no reason in principle why there would be distinction as between raw manure and digestate. And therefore these are matters that the decision maker ought to have taken into account and failed to do so. The other interesting point to draw out, and I think the way the case law is likely to go, is in respect of how the Finch principle applied to upstream emissions. As was flagged in that earlier slide that I whizzed through, Scope 3 emissions do include upstream emissions. The Kilkenny cheese case referred to in that first bullet point was discussed by Lord Leggett. Essentially, the issue there was whether or to what extent there was an obligation to include in an EIA proposed cheese factory the environmental effects of producing the milk needed to supply the factory. So the factory needed essentially 450 million litres of milk that would come from existing sources and was going to be produced in any event. So there are 2 points to draw out from this case. The first one is that in terms of the upstream greenhouse gas emissions from the supply of milk, so from the cattle producing that milk, that was accepted to be an indirect effect and it was capable of assessment. So that came in the sum of, I think it's 513,000 carbon dioxide equivalents. The second point that was raised was essentially the impact on the market. And again, this is a really interesting point when we think about this kind of broader market analysis and any substitutes and any arguments in respect of substitution. On that argument, the way it was formulated was that the factory would increase the overall demand for milk production, which in turn would stimulate milk production, which would in turn mean that there would be implications for the size of the herd. And on that point, essentially what was said is that is entirely elusive, contingent and speculative. And whilst Lord Leggett recognised that the Irish Supreme Court didn't frame their analysis in the terms that he did, impliedly he had applied his principles because they recognised that that second argument, so impact on the market demand for milk, wasn't capable of meaningful assessment. And then finally to flag one to watch, which is in relation to a decision of a local planning authority in North Norfolk in respect of a development for 14,000 pigs and 714,000 chickens. The starting point here in respect of upstream emissions is in relation to the soy production. So that's mostly overseas soy production, which leads to deforestation and land use change, which then has consequences for Scope 3 emissions. What's interesting on that point is that industry groups such as the UK Roundtable on Sourcing Sustainable Soya have recognised that the soy production is associated with or driving deforestation and impacts on Scope 3 emissions. So that's the first point to note. The second point is that these upstream emissions, are also capable of meaningful assessment. And you can see that they're incorporated into various industry standard emissions intensity figures, such as those produced by the AgriCalc carbon calculator. Essentially, those figures can then be multiplied by the total volume of pork or poultry at the facility to give a total estimate for the emissions attributable to that facility. So it's an interesting point. Essentially, the planning officer, recommended a refusal of permission, not strictly on the grounds of scope of the EIA, but in respect of the sufficiency of the environmental information provided by the applicant. Essentially, took issue with there being a failure to assess the upstream emissions, and also whilst the applicant sought to rely on a substitution argument to the effect that this pork and poultry would replace imported pork and poultry, again, that was an assertion without any evidential basis. So The planning committee has accepted that advice and refused planning permission. So that brings it all together. In terms of then just some conclusions before I hand back to Stephen, it is helpful to pin down where the case law has taken us in terms of matters of fact and law and matters going to planning judgment. And I've summarised those points in those 3 bullet points. Obviously, that last bullet ties in with the point that Ruth made in respect to the supplementary guidance and what the law is in relation to benchmarking and contextualisation, which is a point I know that Stephen will pick up shortly. In terms of further developments, there obviously is the question of which legal test of causation will be applied. As listeners will be aware, in the Finch judgment, Lord Leggatt referred to 3 different tests of causation. And how will you go about assessing the adequacy of environmental information, which will in turn obviously assist advisors, advising applicants as well as decision makers. So I'd like to just hand back to Stephen, if I may.
Great. With an advert for the book on the way, so that's fine. So I think we can stop the slides, if that's okay. I was quite interested, I think, to hear that the information notice with regard to Jackdaw was asking for information on cumulative effects, because it's always struck me that when you're looking at scope 3 emissions, greenhouse gas emissions, that cumulative effects is going to be one of the most tricky and contentious issues for assessment. So I mean, we'll have to see how that plays out. But I would have thought whichever way the decision goes on Jackdaw and Rosebank, it's almost certainly going to be the subject of legal challenge. So no doubt these issues will roll through the courts in the months and years to come. But I just wanted to ask both of you really a sort of general question on how these 2 strands, tie together. So we've got the OPRED guidance, we've got the EN1 para 5.2.2, which Steph mentioned, which was obviously interpreted and endorsed in the Boswell decision. So it's really, I think, does Boswell have any implications for how the OPRED guidance is going to be applied and approached? And also, in view of the fact that in 5.2.2 of EN1, it's a clear statement, there's no need to assess emissions against benchmarks such as carbon budgets or net zero, whereas in OPRED, you've mention of the IEMA guidance, which seems to regard that as the crux of the matter. Do we now have a bit of an inconsistency between those 2 sets of guidance? So I don't know whether Ruth or Steph wants to kick off on that, but I think that would be an interesting thing to discuss for 5 minutes, if you can.
Maybe Steph, if I just jump in on an initial point on the wording. I think it's an interesting question, Stephen. Obviously, Steph, you've looked at the Boswell case in a lot of detail for this webinar. There does seem to be an inconsistency there. I think you look at the most recent guidance from OPRED, and it is very clearly saying you can't just provide raw numbers. And the only way to really contextualise your figures is by pitching them against other obligations that the UK has, either domestically or internationally. And I think in the context of that exercise, it's difficult to see how there isn't a tension with EN1 in terms of the exercise. I think if you were to be very literal about it in terms of revisiting the wording and looking at the OPRED guidance, perhaps the distinction is the point we draw throughout the webinar, which is that it's all about information being available so an assessment can be made. Now, in reality, the developer isn't making the assessment. They're kind of drawing the picture that the decision maker is then going to look at. But I think maybe that is where the distinction ultimately lies. But certainly when one reads those 2 documents beside each other now, that does seem to me to be a real difference in approach. If I don't know, given your reading of Boswell, you might have more to add to that.
Right, I think the starting point is that whilst there is some overlap in respect of offshore oil and gas projects that meet the definition of an NSIP within the Planning Act, that they are ultimately governed under, for the most part, separate regimes, separate sets of regulations. I think that's the starting point, even if in broad terms the principles are similar. And the second point to make is that the Court of Appeal didn't close the door to essentially a policymaker deciding to adopt particular guidance to assist in how you assess the significance. And essentially, that's what's done here by OPRED in respect of the supplementary guidance. And so I think what the court people were saying in Boswell was the whole answer, the complete answer was in 5.2.2. Whereas obviously if you're looking at a project which would fall within the supplementary guidance, you would look at both EN1, if that was applicable, alongside the supplementary guidance. I think the other point to make is that going to the complete answer issue, whilst the way it was interpreted in the context of the Boswell case was that that paragraph dealt both with significance and with how you weigh it into the planning balance. When you have separate guidance dealing with significance point, they'll obviously supplement what is said in that particular paragraph.
Yes, I think it's interesting, isn't it, that looking at 5.2.2, the Court of Appeal said you can't really draw it's misconceived to draw a bright line between what goes to the significance of the effect versus what goes to the weight to be given to that significant effect. I mean, you can clearly have something that's a very significant effect, but it may carry not enough weight to prevent the project going ahead in the light of other factors. That's directed really towards 5.2.2 of the N1, but as you rightly say, there does seem to be such a distinction drawn in the policy when you look at the offshore context and OPRED. So perhaps Boswell may need to be treated with some caution, I suppose, when looking at other policy instruments such as the OPRED guidance. Having said that, I mean, it did seem to me that, as the Court of Appeal said, Boswell doesn't really introduce any new law here. It's very much applying straight down the line existing principles of law to the particular facts in that case. Bearing in mind the very big policy imperative behind decarbonisation of the grid and allowing exactly the sort of projects that was under consideration in Boswell. Steph, in looking ahead a bit, where we go from here, one of the very controversial topics is likely to be, I think, data centres. Given the importance which the current government places on data centres as part of economic regeneration, and given the emphasis on that in the trade transatlantic deal with President Trump's government on his state visit here. I mean, is there anything coming up in that area that people should be aware of on the horizon?
Yes, so Foxglove and Global Action Plan have filed a challenge to the decision to grant permission for a large data centre in Buckinghamshire. Whilst the statement of facts of ground aren't publicly available, my understanding is that there is an argument based on Finch. The argument's principally concerned with Scope 2 emissions. Obviously, as we recognised throughout this seminar, that isn't a definition finding its way into the EIA regs themselves. So clearly the Finch principles would apply to Scope 2 emissions as they would apply to Scope 3 emissions. The principal concern there is in relation to the electricity consumption, noting that data centres will require, it's reported, 2.5% of the UK's electricity at the moment, and is like to rise fourfold by 2030. So there will absolutely be a question as to how you go about assessing those emissions in the context of making those decisions. Yeah.
So they'd all better get on with building their own small modular nuclear power stations, haven't they? If they don't do that, then this is going to become a very hot topic, I think. Yeah. Well, I think we've reached 11 o'clock, so I think we'd better honour the timing. Thank you for all of you who've joined us, and to our two presenters. I think we had over 80 of you in attendance when I looked. So thank you all for joining us. And just to recap that you will get from our marketing department a link to the recording of this event, to the slides, and also to a survey for feedback, which we'd be really very grateful if you could take the time to complete, to help us in designing future events. And finally, just to remind you, 13th of November for the in-person seminar, which I hope many of you may wish to come along to Chambers to attend and see us plus many others from the Climate Change Group. So thank you for attending. Thank you for presenting so clearly, Steph and Ruth. I'll say goodbye, and I hope you all have a very good rest of the day. Thanks very much for joining us. Goodbye.
Right.